Trade secrets are a multifaceted part of intellectual property law that are a core part of many businesses' intellectual property strategy. There are many different variables that can be at play in a trade secret case, and no two cases are exactly alike. But the foundational elements of trade secret law are ubiquitous. Today, we delve into the captivating legal world of trade secrets. In the bustling world of fine dining, where secrets simmer, the rags to riches story of a guy named Sid unfolds. Meet Sid, a humble dishwasher at the Cherry Blossom, an esteemed high-end restaurant frequented by affluent and famous clientele. As Sid diligently works his way up the ranks, his ambition and dedication catch the attention of his superiors. In due course, Sid's hard work pays off, and he's promoted to general manager at the Cherry Blossom. His ascent to a prestigious role promises new beginnings and greater prospects. However, the winds of change blow when new owners acquire the Cherry Blossom. Sid's relationship with the new owners is contentious, leading to a fateful decision that alters the course of his career. As tensions escalate, Sid finds himself at odds with the new owners, resulting in his eventual termination from the Cherry Blossom. The bitter end to his tenure leaves Sid searching for redemption and a fresh start. 6 weeks later, a phoenix rises from the ashes of Sid's disappointment. La Fleur de Pommier, a hot new restaurant, emerges as Sid's own venture. The owners of the Cherry Blossom, however, stumble upon an unsettling truth. La Fleur de Pommier is serving a dessert previously exclusive to the Cherry Blossom, a dessert that has a secret recipe. In addition, the owners witness every single one of their celebrity clientele flocking to Sid's establishment. And worst of all, they observe that the exact timing and execution of service, closely held information at the Cherry Blossom, is now prevalent at La Fleur de Pommier. With these suspicions, the owners of the Cherry Blossom accuse Sid of stealing their trade secrets to establish his own restaurant. This case serves as a poignant reminder of the importance of safeguarding trade secrets for business owners. Some of Cherry Blossom Restaurant's most valuable assets was information it viewed as secret. The ways it trains its employees to provide flawless service, its detailed notes on its celebrity clientele, and the recipe for its signature dessert. Could Cherry Blossom Restaurant have done more to protect itself from a highly placed employee's ability to abscond with those secrets? And what harms will Cherry Blossom Restaurant now face with the secrets being not so secret anymore? Have you ever experienced the consequences of a secret that someone else used to their benefit or disclosed to others? But let's shift the point of view here for a moment. What implications do you see if you consider this case from Sid's perspective? Sid was an employee who had served Cherry Blossom faithfully for years and whose skills and knowledge were developed and honed during that experience. Then when Cherry Blossom terminated the relationship, Sid had to find a new job. Does it seem fair and just for an ex-employer to limit Sid's future employment options by preventing Sid from using his skills and knowledge of running a restaurant? Have you ever learned skills on a job and then used those skills in a new job? Today, we'll talk about the law of trade secrets so that by the end of your next class, you'll be able to analyze this in similar types of scenarios. I'm sure you know the basic way of keeping something a secret. You don't tell anyone. But sometimes you need to share a secret with someone else. Maybe you're planning a surprise party for a friend. You're going to need to tell people about the party, but you don't want your friend to find out. That would spoil the surprise. So you're probably pretty careful about who you share the details with and exactly what you tell them. In other words, you'll take reasonable precautions to keep the party a secret. Businesses have been protecting their valuable information through secrets for thousands of years as well. Imagine a medieval bakers' guild, whose members passed down secrets of commercial bread making from generation to generation. That information is valuable to the bakers because only they know about it and can use it in their bread production. By keeping it secret, The Bread Guild has an advantage in the bread production market. Trade secret law is an extension of the concept of secrecy. A secret is only as good as the precautions taken to protect it, and precautions can be thwarted with enough effort, money, or lack of scruples. What trade secret law does is to provide a legal cause of action, a tort, against someone who does something that the law views as improper in order to get at a commercially valuable secret. By providing a legal cause of action, trade secret law limits how far companies need to go with their precautions to protect their economically valuable information. It doesn't require that companies take extreme precautions, just reasonable precautions. However, trade secret law also recognizes that generally competitors are free to copy what they see the competition doing, or can figure out by looking at their competitors' products. And it doesn't provide a legal claim at all against someone who independently comes up with the same secret information. There are two, or depending on who you talk to, three basic elements of a trade secret misappropriation claim. First, is there a trade secret? Second, did the trade secret owner take reasonable precautions to protect the trade secret? Sometimes the law treats the requirement of reasonable precautions as part of the definition of a trade secret, and sometimes it's treated as an additional element of trade secret misappropriation. Finally, was the trade secret misappropriated? Here's an example to illustrate these elements. Ecosolv, producers of exceptional industrial solvents, perfected a unique production process. Their proprietary production process maximized quality and minimized harmful byproducts. Ecosolv took precautions to protect that secret by performing it within a secure facility, keeping files on password-protected computers, and explicitly telling and often reminding employees that the process was confidential. Solvachem Corporation, a rival company, envied Ecosolv's success. Determined to gain an edge, Solvachem's CEO devised a plan to pay an Ecosolv employee to steal confidential files about the production process. A clandestine meeting sealed the deal. The Ecosolv employee, tempted by personal gain, agreed to betray their employer and hand over the confidential files. The stolen files contained a trade secret, information known only to Ecosolv that possessed economic value by virtue of the benefits the process provided. Ecosolv had a competitive advantage by keeping it a secret. Ecosolv also took reasonable precautions to maintain secrecy of the production process. It performed the process within their secure production facility, password-protected files, and repeatedly communicated to employees that the process was confidential. Solvachem's misappropriation was also improper. Bribing an employee to breach their obligations to their employer is a strong example of conduct that is both morally objectionable and legally impermissible. This story illustrates the core elements of a trade secret claim: the valuable production process, reasonable precautions, and Solvachem's misappropriation. So you've just learned the core elements of trade secrecy law and its elements, the application of which relies heavily on context and specific facts. Trade secret issues can arise in a variety of circumstances. There's classic competitive espionage, which I just illustrated. There are also cases that involve prospective business plans that go south after one or both of the parties have shared their valuable information, an example being the case you'll be reading today, Learning Curve versus Playwood. There are also many cases involving departing employees who leave to start their own business or work for a competitor, an example of this being the restaurant story from the beginning of this video. Let's look at the law itself. One thing to note about trade secret law is that it's not exclusively federal. In fact, until recently, trade secrets are almost entirely governed by state law. Fortunately, there's a high degree of consistency in state trade secret law. One way that trade secret law has been harmonized is through the Restatement of the Law, which is a treatise that looks at many different court decisions and tries to identify common principles among them. In addition, while there are many state statutory formulations, nearly all of them are based on the Uniform Trade Secrets Act. While the Uniform Trade Secrets Act provides substantial uniformity, there can be state-to-state variations, so it's always important to read cases from your jurisdiction. In addition, a handful of states have not adopted some form of the UTSA. That said, the foundational elements are pretty universal in U.S. trade secret law. In addition, in 2016, the U.S. Congress enacted the Federal Defend Trade Secrets Act, or DTSA, which created a federal cause of action for trade secret misappropriation. The Defend Trade Secrets Act closely tracks the Uniform Trade Secrets Act. It's a relatively short set of statutes that you should make sure to read before our next class. To orient you, let's step through where the elements of trade secret misappropriation are located in the DTSA. We're going to specifically be looking at 18 U.S.C. Section 1836b1, which provides a private cause of action for trade secret misappropriation. It states that an owner of a trade secret that is misappropriated may bring a civil action, with some additional language that links it to Congress's authority to regulate interstate commerce. Here we see two of the elements of a trade secret claim, that there be a trade secret and that it be misappropriated. A little later, Section 1839 provides the definition for a trade secret. Note that the definition of a trade secret contains the third element, that the owner have taken reasonable measures to keep the information secret. In this instance, the requirement of reasonable measures is part of the definition of a trade secret. So there you have it, each of the elements of trade secret misappropriation and where you can find them in the Federal Defend Trade Secrets statute. Thinking back now to the case of the rival restaurateurs from the beginning of the video, do you think these elements are met in Cherry Blossom's claim against Sid? Now that you know the core elements of a trade secret claim, let's look at the definition of a trade secret in more depth using the DTSA. The DTSA defines a trade secret as information that the owner has taken reasonable measures to keep secret, and which derives independent economic value from not being generally known or readily ascertainable by others who can obtain economic value from its use or disclosure. Let's break those pieces down. As you see in the statute, the meaning of information is quite broad. The statute defines information as including everything from formulas to designs, prototypes, methods, techniques, and processes. This is because trade secrets can encompass a number of different situations in a multitude of industries. It could be a chemical production process, or a supplier list, or technical diagrams, or computer code. Given the broad meaning of information, the key elements of the definition of trade secret are that the information be subject to reasonable efforts to maintain secrecy, and that it have economic value from not being generally known or readily ascertainable by others. Reasonable efforts to maintain secrecy have been held to include advising employees of the existence of a trade secret, limiting access to a trade secret on a need-to-know basis, and controlling plant access. On the other hand, public disclosure of information through display, trade journal publications, advertising, or other carelessness can preclude protection. In addition, the information must have independent economic value from not being known to others. What this means is that the information is valuable because it's a secret, and that the company has some kind of economic value associated with it. As an example, information about what a particular employee had for breakfast might be a secret, but it probably doesn't have that much economic value. On the other hand, there could be information with tremendous economic value, such as perhaps the process for making steel. But if everybody knows that information, then it can't be a trade secret. With this background, you should be ready to read the case for our next class, Learning Curve versus Playwood, which discusses the concept of what a trade secret is and how the elements of the definition of a trade secret can be analyzed. As you read through Learning Curve versus Playwood, I encourage you to think about a few questions. First, what is the asserted trade secret in this dispute? Second, what is the legal framework the court uses to determine whether something is a trade secret? Third, how is the requirement of reasonable measures expressed in this decision? And finally, how would you analyze Cherry Blossom's alleged trade secrets from the case of the rival restaurateurs under the analytical framework from Learning Curve versus Playwood? look at the time. My train's about to leave the station. So with that, I'll let you get rolling on the case. Choo-choo!